Wow. I love it. Yeah, but love the format for this pregnancy. So this is the second year that it's supposed to be like a student that is very technical and this. So after that, from here, we're focused on team to give them like lessons like this, why you do for social, and that so it's just like talk. Yeah. So that they want to hear what the potential, ask what you're, actually, yeah, yeah. So, about yeah, about okay, I'm gonna get started here. Yeah. Everyone, welcome back. Welcome back to our next session. If I can invite you to grab your coffee, grab a seat, and the all-important CE credit code is on the screen right now. If you want to write it down, grab a screenshot, or just enter it. So the CE code for our next session is QBX26. I have a picture if anyone is in the coffee lineup and not able to do that right now. So let me do an introduction for our next speaker. So we have Raman Johal from Gallings here, and she's going to be talking about planning and pitfalls of joint tenancy. I'm sure none of your clients have ever said to you, oh, I'm thinking about just adding my children on title to my house. That way it'll bypass probate. No? No? Okay, I'm the only one that has heard this before. Okay, so Raman's going to talk about all the, what are the pitfalls when that happens. And so a little bit of, so I asked Raman about her costume, and she told me she's dressed up as Amy Winehouse and also Michael Jackson before. Nice work. So, so this is, dressing up as singers and rock stars, what this says about you is that you are sensual and creative, often thinking outside of the box. You have deeply held values which guide your decisions in life. You love new experiences and prefer to jump right in instead of planning out every single detail. Kind and empathetic, you genuinely care about the well-being of others. Despite being reserved, you voice your opinion when it is about a cause that you feel strongly about. You may come across as carefree, but you have a deeper side that you show to very few people. You are keenly in tune with the way things work, look, taste, sound, feel, and smell. You have a gentle demeanor, with others being able to sense your empathy. I don't know how true that is, but this is what Google thinks of, of Michael Jackson and Amy Winehouse. Would you give a big round of applause for Raman here and welcome her to our stage?
I feel like I just had a therapy session there. That was, I felicia like you see me, Felicia. Thanks so much for Advocates for inviting me to speak today. We're probably a little bit, less structured as the segregated funds next door. So this is your chance to escape if you want some of that. As Felicia mentioned, I'm an estates lawyer. So I've been doing this for about 15 years. I guess my passion is the litigation, but I do the planning and the probate administration as well. So I kind of go from A to Z. And I think doing the litigation really helps me get a perspective on how to do better planning. And it certainly does open my eyes to where things go wrong. And knowing that at the end of the day, it's a lot of emotion for folks in dealing or not dealing with their estates. And our role and your role as advisors is to kind of just help them make the best decision. And so I'm here to tell you that estate planning involving joint tenancies, I'm sure you know this already, is not a great idea. I think in my entire career, once I've kind of approved it. I never recommended it, but it worked in those particular circumstances for that particular person. I can't see it working much for anyone. And yet particularly in my community. And I know in other ethnic communities where, family is much closer in title and there's certain expectations. It's seen as this really cheap mechanism to get things done. And I do see more and more and more, especially with property, that it really just leads to litigation. So the planner in me wants you to plan, but the litigator in me doesn't care if you plan or plan properly. So I guess I have empathy a little bit, Felicia, for when you don't, but really, I think you should have just put the money up front and saved a lot of heartache for your family. Sorry, is there supposed to be a clock on here? Otherwise, I'm just going to keep talking.
Yeah.
Oh, there we go. Okay. So I'm
Extra
just
time, yeah.
just going to talk about a few things. I'm sure you know most of this already, but I just want to kind of describe to you how it actually plays out with the courts. And what I found is, despite the sophistication of my clients and perhaps yours in their business and their ability to accumulate mass wealth, their trust of lawyers and their desire to spend money on lawyers is very minimal. And I won't take offense because I know I'm going to get it on the back end when they don't do it right. But, I still wish for people to try and have their intentions respected, or as much as possible, get what they do want out of their life and their families and their next generations. So mainly I'll focus on real property, but most of what I'm saying also applies to bank accounts. And the funny thing is, if you have a client and you tell them, if you put someone else's name on your bank account and they can clear it out, they probably won't do it. And yet the larger, probably more significant asset that they have of real property, in particular in British Columbia and Vancouver, they seem to just turn a blind eye to that, because putting someone on joint tenancy today isn't going to matter until they're gone. And they forget about the intervening years, how relationships fall apart, how you might need money, how the other person might fall into financial straits. And so many things happen. But what you did on the day you made that transfer or put things in joint tenancy is what's going to prevail. And having a change of heart is really, really difficult and expensive to undo. And in most cases, the person who transferred isn't there to give us their evidence and tell us what it is they wanted to do or why they wanted to do it. So we're left to reconstruct. And I know as a parent, I tell my kids different things because it's easier for me. My daughter wants something and my son wants something. So I'll say, well, let's give it to your sister. And then later I'll give you something plus a little kickback, and he's fine. And then later it blows up in my face. And he says, Mommy said I could have this and that. But by then the circumstances have changed and I'm in trouble. I honestly feel parents do this with their estate planning. And I've turned into kind of a hybrid psychologist, I think. They tell different people different things because it's easier for them in the moment and they're not going to be here later. And then it's left to everyone else to figure it out. So going back, I go off on tangent, sorry. Real property, how is it held? What is joint tenancy? Why would you use joint tenancy? And you probably already gathered that I wouldn't recommend you use it very often. And then really the crux of it is, what is the intention? Why are you creating this joint tenancy and to what end? And then I'll have lots to say about the perils. So I didn't realize when I made this slide that I was going to be up before lunch. So I apologize. The spread out there is looking good. And you get a picture of, pizza. And it really is this simple. And I often draw little pictures for my clients when I explain this. And so as it suggests, tenants in common, each owner has their separate piece of the pie. When they pass away, their heirs, beneficiaries under their will, or if they didn't leave a will, which is another separate topic, it'll go by intestacy. It's clear as mud, as my math teacher used to say. With joint tenancy, there's no division. So each owner potentially owns the whole pie when the other person dies. Very simple, right? Okay. So then you put an overlay of this legal jargon called legal title and beneficial title. And on the surface, it looks exactly the same. Our government's caught on to this with the landowner transparency registration, but people still haven't caught on. And so when you pull a land title search, it'll have someone's name on it, a bank account, same. You would hope, you would think that that's it. That's who owns it, that's who gets it. And yet no, lawyers have complicated this all for everyone. So there's this invisible thing called beneficial title, which you kind of have to reconstruct. It's happened so often, like I said, that we've got landowner transparency registration, which is kind of new. So in November 2020, the government required that anyone who is having or getting a new interest in land had to register legal and beneficial title. For those who had to report for property already owned, that was November 2022, which is a year ago. So I haven't seen a lot of this come up in the courts, but I imagine I will. I have one in particular case right now where I think it will come up. So while a person's name is on title, they don't actually beneficially own it. They are holding it in trust for someone else. So if I put my daughter on title to my home, I have 2 kids, you'll hear a lot about them. And I say to my daughter, I'm saving probate fees, which I think people assume probate fees are worse than they are. It's 1.4%, which can be a lot in Vancouver, but when you look at capital gains or other, problems, it's not the worst thing that can happen. So I say, daughter, I'm going to give it to you because your brother's a spendthrift. He likes to buy, expensive shoes and cars and whatnot. So I'm going to put it in your name. You're more financially responsible, but just know that when I pass away, you'll save those probate fees, but then you have to share with your brother. Yeah. A lot happens. And, they have a falling out. And when I pass, she hates him, he hates her. And, it's all hers. Mom promised it to me. Mom didn't tell son anything because I didn't trust him. And you can see how all of these things happen. Our law has created this presumption of resulting trust, which I'll talk about in a minute. And the only person actually, other than the family, who cares about this is CRA. You'll find they have their own set of rules, their Bible of beneficial and legal title. And it's almost worse dealing with CRA than it is to deal with judges in courtrooms. So what actually is a joint tenancy? Legal jargon, there's 4 unities. So you don't just go and, put someone's name on title. Later on, courts will look at it and figure out what it is, whether these 4 unities existed. And so for the first, it's interest. Each tenant's interest must be the same. It's the same nature, same extent, same duration. So you kind of get that from the pie. You can't tell the difference. They're both, they both have the same interest. Each tenant's interest must arise out of the same instrument or act. So typically what I see is a parent owns a property, and then at some point they transfer it into joint tenancy. So they're actually transferring it to themselves and another child or another person in joint tenancy. So that transfer, that instrument, gives them both the same instrument, or say the same interest. When this happens, it happens to both the same people at the same time. So like I said, that transfer happens, they both get the same interest at the same time. The thing that people don't appreciate, the parents who put a child's name on title, is this possession issue. And it doesn't mean that they physically live with you. So there are circumstances where, maybe it's a failure to launch kid, or maybe it's the other side of the spectrum where the kid takes care of the parents and the parent puts the child's name into joint tenancy. And they both live there, but you can put a child's name on title and they don't live there. Of course, capital gains and property transfer tax and all of that is an issue. But what it means is that child who doesn't live there, that's on title, can come in and move in at any point they want. They have the right to possession. They have a right to live there. They have a right to sever the joint tenancy. They have a right to encumber the title. And people don't think of these. They think, when I'm gone, everything's going to be fine. We'll save those nasty probate fees. And what they also don't realize is there's various ways to sever a joint tenancy. One owner can go to land title, file a simple form, and it's 2 halves, so 2 pieces of the pie. Through a course of conduct, there's certain things, I won't get into it so much today, but there's certain things you can do or not do that lead a court to believe that you always ever had, your 2 halves. Sorry. Or you can both agree. Wouldn't it be nice that everyone just agreed? And often these cases that come to court are those ones with regret, and the new tenancy or the new joint owner just doesn't feel like giving it back. So with right of survivorship, that's pretty easy. The surviving joint tenant becomes the absolute owner of the property by right of survivorship. The gift of the right of survivorship is irrevocable. You can't take it back, and it gifts and vests at the time the gift is made. So if you change your mind later, it's too bad. This doesn't prevent the transferor, so say mom or dad, from dealing with the property while they're alive. They can even eliminate survivorship by withdrawing from a bank account, like I mentioned earlier, or by severing joint tenancy to get 50-50. And the transferee is only entitled to what's left. Just stand there and hold it. So with respect to bank accounts and real property, this is kind of probably too much of a technicality, but our common law, so judge-made law, assumes certain things with respect to personal property versus real property. And so where there's no indication, where we don't know who might own or not own, there's a presumption of joint tenancy for real property, for personal property, but for real property, it's the opposite. So they assume a tenancy in common, but usually you have to check a box for one or the other when you file your forms at the land title office. So this is going to be a short slide. And I know it's saucy, but it's true. So yes, there are legitimate reasons why. The big one that people all talk about is probate fees. And like I mentioned, it's 1.4%. You know, it's a drop in the bucket compared to other things. Then there's the right of survivorship. I get that there's certain situations where this works. If you only have one child and you're, 80 years old, you might want to do that, but there's no guarantee. I probably wouldn't have a career if you knew when you're going to pass away. Like that's the one thing we haven't figured out yet. And so, knowing there's a closer end might be a reason why. But certainly if I was in my 50s or 60s, I would never, ever recommend to anyone that they. Definitely. Most. You're absolutely right. So I should give the caveat. I'm talking about when there's one spouse left. So most couples have a joint tenancy, but I gotta say, I had a client about a month ago. This gentleman calls me, married with his spouse, second marriage for both, each have their own children, and they have one joint child who I think is about 13 or 14. Very happily married. They ran a business. He was happy with what was in the will. He knew it was in the will. Sadly, wife had cancer, so knew the end was nigh. Unbeknownst to him, she severed joint tenancy of their primary residence. So, split families are the other, wealth of an estate's litigator. I'm sorry? Definitely, and bad cases make bad case law. But what I'm saying is, I don't think spouses are immune from this either, because you have more and more blended families and people want to leave to their children. And so, yes, the default of spouses joint tenancy, great idea. It falls apart in certain ways because they didn't have that discussion. And it actually led to a big problem with, renewing the mortgage at that time. And it was a huge issue. Lucky for him, he didn't want to litigate. Bad for me. Because he had a great relationship with these kids, but it caused a problem. And if they'd had that discussion, it could have all been avoided. But you're right, spouses, it's typically a good idea. I'm mostly focused on these ne'er-do-well children and this huge transfer of wealth that's going to happen to the next generation in these coming years. So when using a joint tenancy, like I said, if you know and you maybe have limited heirs that's where you want it to go, great idea. if you communicate with each other or your family on what you're doing, I think that's key. So often there's a lack of communication and misunderstandings. But really, I said it was saucy. I think it's lazy and cheap to do it when you have other options. You can create trusts. You can, you guys are well versed in other options that would be better for the individual than a joint tenancy. So this is the main thing here, intention. When these things go to court, the court is going to look at intention, the intention of the transferor, and it's very difficult to know what that is when they're gone. You're left reconstructing what they wanted. You're left with individuals who now have a very, very significant vested interest for a valuable asset if it's real property. And so the courts have basically said there's three potential scenarios. If there's not a declaration of trust or documentation about what they wanted, there's three possibilities. So one is a joint tenancy, where each is the owner and enjoys full ownership of the property, and then the survivor will get title to everything. So that's kind of the typical thing we think about. The second is a resulting trust. And so this is where it gets murky. And that's where one joint tenant has beneficial interest, so that amorphous kind of invisible thing. And the other who's received it holds legal title. And they can both have legal title, but the one of those two is the actual person with only with beneficial title. And so that's the example where, dad puts property into the name of the son with the expectation that son's just a placeholder. He's not going to do with anything with this property until dad passes away, but really he's holding it on trust for dad's estate to save those dastardly probate fees and then distribute it to the rest of the family. And the third scenario is sometimes referred to as a gift of the right of survivorship. So it looks the same as the second scenario, resulting trust, but dad wants the son to have it. He doesn't want the son to do anything with it while he's alive. He doesn't want him to possess it. He doesn't want him to declare the rental proceeds. He doesn't want him to share it with his siblings. It's for the son. And so that's the gift where you've given them the right of survivorship, not beneficial title, but that they get it. And if you're on the outside, how do you distinguish between any of those? Like, there's no way of knowing unless you've documented your intentions. I should have put actually next to deed of gift, declaration of trust. So oftentimes, well, every time a parent decides to do this, and it's the parent, not talking about spouse, you should say, well, do you want to give a gift to this child, or do you want them to hold it in trust for your estate or for someone else? Have that conversation and document it. And the funny thing is that people try to do this still and they mess it up. I have a file right now where a dad did a deed of gift for money that was put down on property, but also a declaration of trust. And so it says the property is beneficially owned by dad, but dad said this money that you put towards the property is yours as a gift. So does that mean that the estate gets the benefit of that gift of those funds? And they didn't file a landowner transparency registration. They didn't file a declaration. So that'll be interesting because those things are working through. But the presumption of resulting trust, like I talked about, when a parent transfers to a child, it's presumed that they're transferring it on trust for some other purpose. And then the child has the obligation to rebut that. They can say it's a gift. Here's a declaration or a deed of gift. Dad, mom said I was to have it outright. Or they would say, here's a declaration of trust, and dad didn't want me to have it right away, and I'm going to hold it on trust for someone else. The other option around this presumption is for the child to say, well, I've contributed to this property. Here's, an invoice for renovations that I made. And the contribution from this child doesn't have to be the value of this property. So if it's a $2 million house, you'd think, okay, half, the kid put in $500,000. Nope. The kid could have renovated the basement. The kid could have taken care of the parents in lieu. They could have, maintained the property over the years. And this is the problem you have when you have a child who lives in the home, who's become the joint tenant and, is contributing in some way, so that it could look like it wasn't just, a resulting trust, but they're paying for this big gift, and then it's not a gift. There's so many cases that I just want to talk about one of them, a couple, but these are kind of more recent, and in terms of regret and in terms of what the evidence is that the court looks at. So it's a case out of Ontario, but there's similar cases here. We've got Mr. Jackson and Miss Rosenberg. So Mr. Jackson brought a court application to have a declaration, so a court order saying Mrs. Rosenberg held title to this property on resulting trust for him. So he's saying he still holds this beneficial interest and that she's just on title, on paper, the owner, but really it's mine. He did this, he transferred this several years prior for no consideration. So she didn't pay him. So it looks like a resulting trust. But then the court looks at, they do care about the intention at the time, but they also look at what's been happening following. And really what kind of turned the tide here was Miss Rosenberg's husband went to Mr. Jackson, who's a bit elderly, and say, hey, you know what we should do? We should renovate this house and sell it and then buy a nice smaller place on a golf course for all three of us. Well, Mr. Jackson got very upset and wanted to sever the joint tenancy and undo all of this. Certainly he's entitled to sever the joint tenancy, but he wanted to undo the entire thing. And the court really looked at his intention at the time. At the time, they said he gave the right of survivorship to Miss Rosenberg and that in equity, it should pass to her. That was the fair thing to do. And so it wasn't, a gift to her outright, that first scenario. It was, she's not meant to do anything with it, but she gets it when I pass away. It's still hers though. You can't undo that. And so the court said he's free to sell his half, which nobody really wants to buy. He's free to encumber it. But at the end of the day, he's now got 50 and she's got 50. And the court really went to great lengths to say that joint tenancy is a really, really risky way to just avoid probate fees. The other evidence that the court will look at, like I said, is rental proceeds. So I own a house, it's in joint tenancy with my child. I want them to have it when they pass away, sure. Or I want them to share it with my other children when I pass away. But the point is, during my lifetime, I'm the beneficial owner. It's still mine. I declare the rental proceeds. I pay the taxes. I deal with the repairs. So overtly, openly, it looks like mine. I act like mine, but at the end of the day, it will go to someone else. You can see how it's very blurry what happens when, you're secretly doing something, telling different people different things, and not really paying attention to the long-term consequences. So you probably know property transfer tax into joint tenancy. There are exemptions when it's a related individual, like a child or a spouse or something like that. So there's no property transfer tax. There certainly are situations. Actually, it's the one situation where I agreed that a joint tenancy was a great idea. It was random. This lady, she's about 86, sharp as a whip. She had come into a lot of money. She lived in the West End. Her parents owned several buildings in the West End. When they passed away, she and her brother came into significant wealth. And she, I wish I knew her, she's his guardian angel, thinks because real estate is so expensive, she wants the younger generation to be able to own property. So she walks around like this landowner giver in the West End, giving large amounts of money to people she doesn't know that well. And it's crazy, right? You want to see this. So she also has a home in the West End, one of those character houses. She lives in one unit. There's a lady who lives in another. They became very close. She gave her power of attorney. Ultimately, she wanted to leave this big property to that individual. And red flags all over the place for me. Why would you do that to this person you've known for 3 years? And I said, if that's what you want to do, you're competent. You got plenty of other money. I'm telling you that she could sell it from out underneath you, and you don't seem to care. Plus, she actually had an established history of giving large amounts of money to people to buy their own property. So that's the only situation where I've kind of given it a pass. But usually you have the, small family, their home is their primary, investment. It's really risky to put anybody else's name on top of that. I talked about CRA. Oh, I was joking.
So sweet.
Do I sound hoarse? Wow, lovely. So capital gains, basically the CRA says, if there's no change in beneficial ownership when the property is transferred, there's no disposition, and so there's no capital gains triggered. Great. You still have to prove that. And so again, it goes to the intention when registering the property in joint names. And I have a terrible story for you. So I met with a gentleman last year, and he decided when he married his second wife that he was going to put his home into joint tenancy with his son to save it from his spouse, which is not true, but anyways. So he's living with his second wife. They seem to be getting along just fine. And, 10, 15 years later, he decides, oh, well, I should put that back because I really don't want to leave my daughter out of the loop. He did great planning at the beginning, though. That's the thing. He had a declaration of trust. He documented that he was giving beneficial interest to his son. Sadly, his son became a non-resident. He went to the UK, which raises a whole other host of, taxation issues. The son was very willing to give dad his property back, but does he want to? Because that was going to trigger huge tax consequences. And so, when that wasn't the case, when there isn't a declaration of trust, you might be able to kind of go back to CRA and say, listen, dad didn't give a beneficial interest away, but he documented that time that he did to save it from the wife. And now he's in dire straits with the CRA. So the long reach of the CRA can get you, and you really have to establish and show them why you didn't change beneficial title. In this case, I think, unfortunately, this gentleman is out of luck. This other issue with creditors arose a couple of years ago, and it was poor Miss Gully. She had a house in Burnaby, and several years after owning it, she got tax advice that she should put it into joint tenancy for her son. I did not give her that advice. And this was to avoid those probate fees. So mom put son on title. Apparently he didn't know, and she didn't know that her son got into a bit of a financial sticky situation. And at the end of the day, he consented to a judgment in favor of a construction company for $800,000. And then the construction company found out that he owns this property because he owns it. He's on title. And so those typical arguments come out. Mom says, well, listen, I didn't give him the beneficial title, and so it wasn't a gift. It was only to take effect when I pass away, but I retain all rights. And this is the other thing about courts, which I don't think people appreciate, is you might have the law for you, you might have the facts for you, but if you have a prickly personality, you could lose. And so I think here, mom was trying to get out of having her house taken away by this construction company for these creditors for this son, but it didn't really, go according to plan. So what the court had said that even if mom hadn't intended to gift the property to the son, then the son was still holding it on resulting trust based on certain provisions of the Land Title Act. At the end of the day, she lost, the son lost, but they actually didn't raise the possibility of the gift being a right of survivorship. Like there wasn't enough evidence to support that. And so that was the downfall. It's all about evidence, and it's all about, the difficulty in undoing these things. So, like I said, use it sparingly. I've only, and I wouldn't say recommended, I acquiesced to it once. And, I think what I would tell my clients, and what I do tell my clients, is pay a little bit more now for good estate planning advice. Know that you cannot change your mind, and know that it will be very, very expensive later if you try to change your mind, or if people are going to litigate this because you didn't do it properly in the first place. People need to communicate better, and there's always this secrecy involved in what they're planning. They don't want their kids to know. They tell them different stories. They're worried it will be, used against them. Sadly, our population is aging more and more, and certain people become a bit more paranoid when you start asking them and pressing them, have you done your will? What are you doing? They don't want conflict. Then they get suspicious. I see it again and again, and it really just destroys families. So to the extent possible, I know your client is your client and your loyalty is to your client, but please, 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 if they're doing this or something else, try to encourage them to share their intentions with those left behind, Because if they don't, they're going to become my clients, and I'm very happy about that. People need to start using this landowner transparency registry. It's still in its infancy, so we don't know what kind of strength that evidence will have. Like I mentioned before, I have a case where dad, did the deed of gift, but also declaration of trust for 4 properties. They never filed a declaration in the land registry. And so that's going to really be a problem for him. Get accounting advice. If someone can maybe just show you the math, probate fees versus potential capital gain, it might open people's eyes. I find, pictures and graphs are great. Scaring them, telling them that I'll take their money after in litigation does work. If you want me to talk to them, I will tell them that. But really, I think like Felicia said, I've got a little bit of empathy. And so while I am a lawyer and I love doing this for a living, it does kind of break my heart when people's hard-earned money is wasted in litigation, which didn't need to happen. So that's all I got for you.
Thank you. Yeah. Thanks so much, Roman. We have time for Q&A. So maybe I'll start. Yeah, if you can, we'll get the mic runner to come to you so we can hear it. We have a mic over there. In the meantime, I'll get started with an online question first. This question is from Evan. He has a question about moving primary residence into a joint spousal trust. Issues of claiming principal residence exemption on death of second spouse, property transfer tax potential on initial move into trust. What are your thoughts? Right now, what are your thoughts?
Can I just see that?
Yes. Yeah. So yeah, transferring principal residence into a spousal trust.
Well, I don't like it.
She doesn't like it.
I don't like it.
Don't do it.
It limits what you can do with that residence. What I find just on a practical level is people downsize or need to downsize, and you're restricted on what you can do once it's out of your hands in a trust. So if they have other options, I would suggest doing that. So I don't know, actually, I don't know about the exemption for the property transfer tax when they should move into the trust. Does anyone else know that? Evan, I'll have to get back to you when I talk to the tax expert at my firm. Yeah, sorry about that.
That's okay. Thank you. And then we'll take a question from gentleman at the back.
Yes, I have a comment about using if they're assuming the person's over 65, using an alter ego trust as opposed to joint ownership. Because that is, you're dealing with still alive, you can move the particular significant amount, you can do the transfer without no tax payable. There are some different ways you're taxed on the income, but is that a better solution? Because now you still control the property, you can take the property out, you can get all the income as opposed to joint ownership.
So this is one of the things I was talking about earlier, where it's documented and where it's, there are other options, right? With the joint tenancy that I'm against, it's where it's just put someone else's name on it because it's cheap and easy to do. That's excellent planning. Let's push people to do more planning that involves more options and more control. But just this, going to a notary, and just transferring it over is just fraught with peril. And so, yeah, if you can give them advice to do something else, I think it's a much better option.
Okay, thank you. We have also another question online. This is from Corey. So if only one spouse is on the mortgage, can the other spouse be added to the title? My client was told no by the bank.
Oh, banks. It depends on what the bank, if the first person is the one holding the mortgage and responsible for it, there's no issue in my mind on adding the other person. But really that's in the control of the bank. So this example I gave earlier, where this wife, unbeknownst to husband, had severed joint tenancy, he actually was unable to get a mortgage once she passed away because he only owned half of it. And that was when the interest rates were exploding. So he got hammered pretty hard there. But really, I think the banks kind of hold you at that point. And I've never quite been able to understand certain protocols and certain decisions by certain banks and not other banks. But legally, sure, if one can pay for the entire mortgage, there's no issue with putting the other one on title. I think the banks control whether that actually happens or not.
Okay, thank you. Any other questions from the audience here? Yeah,
Hey, Roman.
Hi.
We see a lot of these issues show up post-planning. So so post-death planning, right? So post-mortem planning. Can you talk a little bit about, a lot of times, a parent will think it makes a lot of sense to put a child on their bank account or for ease of access, or if they're starting to slow down. The real pitfalls around when something like that happens, that sort of loops back into your presentation, and then building on to the gentleman behind me, what type of trust do you see that we can deploy or weaponize to sort of to make more of a smoother process when that transfer of assets occurs?
So you're saying during their lifetime or after?
Yeah,
Right.
so I think what I'm asking is when a lot of times a parent will put one of their 2 or 3 children or 4, however many they have, onto a bank account, not realizing what the
Implications.
issues might be
Yeah.
later on when they're no longer with us. And then what's the better way of giving children access without creating issues after death?
So I would encourage the parents to not put the child on title, but give the child a limited power of attorney. And that's twofold. The power of attorney can be very specific to a very, specific account and things they can and can't do. To be generous, the power of attorney can give the child the ability to make gifts if that was a pattern that the parent did before. Because what I find, once a parent has lost capacity, giving out big gifts, if it's not specified in the power of attorney, it's not possible. But the other kind of safety mechanism is banks are very attuned to misuse of powers of attorney now. And they have obligations as well to the account holder to make sure that their funds aren't dispersed. So I actually think that's a better way. It's kind of a hassle because the banks do interfere a bit too much. If anything, they're overprotective. But I would say a power of attorney that's limited is the best bet in terms of, acknowledging what the intentions are, limiting access, and then also kind of having the bank as a safety net to make sure that the child doesn't completely swindle mom or dad.
So a quick follow-up. We're also seeing where, out of multiple children, there may be one child that needs more financial help to get into, let's say, the real estate market and own a piece of land. How do you make sure that if there's a living gift happening to help fund that purchase for a child, how do you create that equalization? How do you document it? How do you make sure this doesn't be, you don't end up with that case?
So you can put in the will what the intention is. Obviously, if it's a gift, do a deed of gift at the time. But in your will, you can also say, I've advanced X dollars to this child, and so I'm offsetting that for what I'm giving the other children, or that's in addition to what is given to these other children. So you can make mention of it in the will to just solidify why they've done that. And then so I was just going to say, we have this lovely thing called the wills variation in British Columbia. So if under a will, a child or spouse is not treated fairly, very ambiguous word, they can challenge the will. And so the court looks at what's in the estate. So if you've got $1 million estate and mom and or dad, let's let him live longer. So it's $1 million estate, 2 kids, 50-50. But then you find out kid A had gotten $1 million the year before that didn't fall into the estate. Kid B can challenge and say, listen, what I got was unfair because I got a meager $500,000, whereas he's ended up with $1.5 million. So our court will consider gifts beyond what's in the estate to equalize or make fair, if a challenge is brought. Same with declarations, beneficiary declarations and that sort of thing can be included as well.
okay, thank you. Is there one? Oh, there's a question. We come to the front. Oh, no, we're for the virtual attendees. Yeah, they can't hear our question, so it's good. We want to hear your voice. anyway.
Okay, great. I just gonna say, just back on the deeds of gift, what are the witnessing requirements for that? I mean, can dad just kind of say here, I intended to do this? If I had to get through.
He can, but should he? I find it's an excellent practice to have it notarized, with hopefully an independent counsel. The last thing you want is for the son to take dad to his lawyer and have that lawyer draft something that dad signs. So you want to have a level of kind of separation where dad had the option of getting independent legal advice, but then there's also someone there who, notarized it. So some people write it on a napkin. It's terrible, but it's still evidence. But I think the stronger you can have towards ensuring that it looks like they got the proper advice before signing that document and having it with their own separate counsels, probably the best idea.
And then, yeah, one question.
I have a different type of a question. It has to do with the introduction of MAID into our world, which last year, I think in British Columbia, close to 8% of the people who passed away are taking advantage of this. So it's a big deal.
Yeah.
So when you make one thing about MAID, you have a date at which some event is going to occur. So transferring property, then the person has to be mentally competent. They have to have 2 doctors do it. So they have to be, so that part of it is there. You have to deal with the influence issue. But is that something in the legal profession now you're saying, someone's going to pass away on October 31st, for sure. They've selected that date. Is that where we should be transferring the title then to the 2 children or whoever it is? Because they're going to, the day she passed away on November the 1st, they're going to be transferring it through land titles through probate.
Definitely. I mean, I guess I was flippant before when I said if we knew the end. In that case, you do know the end date. And I do see that. I have litigation files where I'm about to claim undue influence or lack of capacity, and I find out that the deceased has passed away through MAID, and I know that's completely not gonna work. And so, yeah, I do see a lot of planning and transfers into joint tenancy with the child. And the one I'm thinking of, the father had about $5 million in assets and another property, and he put that property in one daughter's name. He had 5 other kids. And I surmised that there was a developer going on, a development going on nearby. So he put it in the daughter's name to facilitate transferring it, selling it to the developer. So I have this whole other reason why, but he didn't actually document why. So he still needs to, even if you know the date and it's implied that it's part of estate planning, did he plan for her to keep everything? Or did he plan for her to sell it because there's a developer knocking at the door and then share it equally? We still didn't know. So again, we need to kind of document and have intentions.
Thank you. Okay, with that, I'm gonna let's give Ramon a big round of applause for her time here. Thank you.
Thank you for my water.
Thank you. So what I gathered from this is you're either going to work with Ramon upfront or you're going to work with her later. You just pick which one you're going to, which time frame you're going to work with her. So I encourage you to continue connecting with our speakers. If you have questions, they'll be around during the day. Okay, so a couple of announcements before I send you off to lunch. We are actually having a contest coming. I'm the contest girl here. So there's an Indochino contest in your feed loop. Indochino again is the company that sponsored, the suit here. So you'll notice that they're on site. So if you mention Dress the Host, there's a 20% off discount for custom suits here. And they're actually also doing a draw. So for a free suit. And I believe that our friend, I don't know if Donna Thorne from PPI is here in this room or the other room. She won a suit last year. I don't know if she's wearing it today though. You can ask her. So they're here from 12 to 5 and they'll be handing out 1 free custom suit. So how you enter is to visit their display outside to book a custom fitting appointment. Then the lucky winner will be announced at the end of the day and you have until 3 p.m. to visit their display to enter the contest. Before I let you go off to lunch, I would like to invite Jacqueline Nobloch here, and Jacqueline's is part of our advocates board, and she's gonna give an update on advocacy.
Hello. I'm excited today because the last several updates I've had have been what is title protection, what are we trying to do, and we repeat that message for the next one. As of today, we actually had some action from the last message up in the spring, so that's exciting. There have been several of us who have actually spoken with local MLAs, Brent in the back, Angelina, who's presenting currently next door, and myself. and actually spoken to representatives of the BC Minister of Finance Department. And so we got 3 good takeaways. One, they know who we are. So they know who Advocates is. They're aware of what we're trying to accomplish. They know what's happening in Ontario and other provinces and what they've been doing. 2, they don't think there's a big enough issue. They don't think that we're a priority right now in terms of our request for trying to work on title protection. And that's just because they haven't heard enough horror stories. And when you read all the headlines, there's a lot of horror stories going on. Most recently, I think people are impacted, obviously, with the changes to the short-term rentals and such. So when they look at the hierarchy of the things they're dealing with, title protection for financial planning, that type